I want to accept some of your directions because you are the speaker, but under protest. Number one is lumping me up with people I have opted to disagree with, and therefore saying, all of you minority, you are lumped up together and you are given the same time. That's number one. Number two, that even where you, Right Honorable Speaker, and with immense respect, do not contain your members. You allow them to present for more than the time you had originally apportioned for all of us. Then when I come, you say 2 minutes. I know that in my wisdom, collected by age, among other things, I am able to present this in those 2 minutes or 5. But I also know that the country will not benefit. With that said, Right Honorable Speaker, let me thank my colleagues that have presented before, both majority and minority. Let me also associate with the bulk of the minority presentations to avoid repetitions. Why I opted to disagree with some of them, including the minority, is that I did not read any amendment purportedly presented by the Honorable Attorney General. My construction and understanding of the presentation by the Attorney General, I read it, I know he skillfully wrote in small words views of the Honorable Attorney General, and then in big letters on the Sovereignty Protection Bill. But I treat them not as an amendment. However, I treat them as views of a stakeholder. Reasons or points of dissent. I have summarized at page 1, insufficient consultation on the bill by government and the committee. The bill inverts the constitutional concept of sovereignty in favor of the state in contravention of Article 1. The bill is accompanied with an incurably defective certificate of financial implication. The bill infringes various principles and articles of the Constitution. The bill does not cure any mischief and is therefore misconceived. The bill is redundant as there exists sufficient legal framework to cure any mischief. At page 2, Right Honorable Speaker and colleagues, 3.1 on insufficient consultation by the government and the committee, I have stated what you're able to read, but with emphasis on Article 1. I also emphasize that the consultations were conducted here and we've never moved anywhere outside Parliament, as if the rest of Ugandans have no views to contribute on such an important subject. Sadly, influencing government policy is sought to be criminalized in this bill. See Clause 7.4 of the bill. Right Honorable Speaker and colleagues, at page 4, I traverse the reasons that I have given, and I cite the case of Malema Bilis and others versus Attorney General, Constitutional Petition number 2 of 2018, and the decision of court to the effect, in summary, that consultation is not cosmetic, but goes to the root of our constitutional governance. In 3.2, that the bill inverts constitutional concept of sovereignty in favor of the state and contraventions of Article 1 of the Constitution, I associate with the elaborated submissions of my colleagues to avoid wasting time and eating much into my 2 minutes. 3.3, Madam Speaker and colleagues, the bill does not cure any mischief and is therefore misconceived. And the summary of this, one is that there exists sufficient legal framework. But if you look at page 6 of my submission, it is sought to be understood that interference with the development and implementation of government policies and programs, which interference is funded by foreigners, and agents is the mischief. That foreign aid to civil society that comes along with conditions and parallel programs which conflict with government programs. This has given external donors, I understand, significant influence over Uganda's political, social, and economic landscape, which has resulted into erosion of our values. See that the use of online platforms by foreigners and agents of foreigners to disseminate information facilitates social discord. The minority, and that is me now because it is a single man's minority report, note that the bill is misconceived since it is based on the wrong premise, that Uganda has no specific law upholding sovereignty of the country, which has resulted into continuous interference in the government's policies and programs by foreign countries and agents of foreigners. That no laws exist on the book to regulate activities of civil society, and that the law regulates the use of online platforms. I note that, one, the Constitution only guarantees sovereignty of the people as against the state. No wonder the laws of Uganda are silent on this matter. There exist laws which include, among others, the NGO Act, the Money Laundering Act, and the Penal Code, which are sufficient to guarantee our security and sovereignty. In addition, I note that the bill further is misconceived because it restricts funds procured from abroad, thereby indirectly affecting the operations of financial institutions and the Bank of Uganda. Let me note that the majority report was uploaded yesterday at 4, so this one is taken care of. And for that matter, I will proceed to the next. It creates a regulatory arbitrage by extending the bill to persons and institutions already regulated by other acts of parliament. For emphasis, honorable colleagues, each and every sector we are talking about is regulated, including the political sector, which is so to be the target of this. And you are able to read for yourselves A up to K at page 9. Right, Honorable Speaker and colleagues, although the bill seeks to safeguard the sovereignty of Uganda from external influence, it grants agents of foreigners, once registered, the right to interfere with sovereignty. For instance, an agent of a foreigner who registers with the minister can implement government policy or government services under Clause 6. Strangely, can influence development of policy under Clause 7. Can implement government policy under Clause 8. Can interfere with the electoral process under Clause 11, simply because of registration. All the activities that are allowed for an agent of a foreigner under the bill will affront Article 1 of the Constitution, whichever way you look at it, even when the minister allows. It is an affront. And the bill assumes that what is offensive to the Constitution becomes lawful simply by allowing it under an act of parliament, insofar as they will infringe the sovereignty of the citizens of Uganda by subjecting it to the influence of foreigners. The so-called acts allowed under the proposed law will still be offensive by their nature, being an affront to sovereignty. The minority note, therefore, that had the bill been conceptualized properly, indeed by being overly vague and ambiguous in relation to its application and the activities it seeks to regulate, it may be declared void for vagueness and the stretching beyond the parameters of the Constitution. At page 9, the bill infringes several articles. My colleagues have mentioned quite a number, specifically Article 1. I also opine that it offends Article 259 to the extent that it seeks to amend the Constitution by infection. This was canvassed in Paul Semogere Zakalo Luma and Juliet Reina Kafire versus Attorney General, Constitutional Appeal number 1 of 2002, in which the Supreme Court declared Section 5 of the Constitution Amendment Act 2000 as unconstitutional since it had the effect of amending Article 28, Article 41(1), and Article 44(c). Right, Honorable Speaker, In that case, it was declared unconstitutional for having been passed without following the procedure under Chapter 8 of our Constitution. Unconstitutional deprivation of citizenship. Right Honorable Speaker, citizenship is not granted by statute. By seeking to reintroduce the foreign element against Ugandans, the bill offends Articles 9, 10, 11, 12, 13, 14, and 15 of the Constitution. Freedom of expression under attack. Article 29, 1A and B, which provide that every person shall have the right to freedom of speech and expression, freedom of thought, conscience and belief. Now, clauses 5, 7, 8, 9, 7, 8, 10, 12, and 13, and the definitions of disruptive activities in Clause 1 directly criminalize expression and association, including influencing the public to oppose the policy of government. Clause 2(2)(g), engaging or participating in a riot or unlawful demonstration or assembly. The definition of disruptive activities is offensive. And publishing information said to weaken the economic system. Clause 13. These restrictions are neither demonstrably justifiable in a free and democratic society as provided for under Article 43(2)(c), which provides that public interest shall not permit any limitation of the enjoyment of the right and freedoms prescribed under the Constitution beyond what is acceptable and demonstrably justifiable in a free and democratic society. 3, freedom of association and assembly threatened. Right Honorable Speaker and colleagues, Article 38(2) of the Constitution guarantees every citizen's right to participate in peaceful activities to influence the policies through civic organization. Now listen to this. Clause 7(3), Clause 8(3), Clause 8(4), and 12 substantially burden and in some places extinguish that right by criminalizing conduct that constitutes its core exercise. 4, right of equality invaded. Under Article 21(1), all persons are equal. Now, when it comes to the definition of foreigner, a Ugandan citizen residing outside, that has been sorted, and I accede to that. Then the foreigners in their own country and converts persons into those who deal with them. Intrusion of privacy, where the minister, the right to privacy of a person and property, and no person is subjected to unlawful search or unlawful entry into the premises. Clause 28 confers the person appointed by the minister to inspect the premises on an agent of a foreigner. Void for vagueness. I think the Honorable Betty Namboze has hinted on it, on the wide and arbitrary provision. Authorities to look at are Andrew Kalamaji versus Attorney General, Constitutional Petition number 5 of 2016, which struck down Section 25 of the Computer Misuse Act